You got it?
Yep.
All right. And thank you, everybody. Salam alaikum. Suad Waiqof Kaniti from GBS, Mommy's Corner / Mahadsantin. Everybody welcome. Today is Saturday, as we meet every Saturday here at GBS / Mommy's Corner. We have a Christine here today who is going to be doing presentations. Please help me to welcome. I'm going to be away from here. Sorry, guys. I'm going to pin you, Christine. I'm going to be away. I'm at the hospital doing delivery. So inshallah, Christine, welcome. I'm sorry I didn't give you a great introduction, but I'm sure you're going to do a great job introducing yourself.
That's
and we
okay.
have if you can
like we said earlier, babies come when they come. So do what you got to do.
That's right. And I can't believe you guys, I'm in the bathroom. So take it away from here, Christine.
Okay. So everybody, hopefully everybody can hear me okay. I'm going to be sharing my screen here in a couple minutes, but I just wanted to introduce myself. I'm a volunteer with Eastside Legal Assistance Project. And when you get to the end of my presentation, there's some contact information on how to reach out to Eastside Legal if you think you might qualify for services or have further questions. And like I said previously, I'm gonna, on my handouts that I've given to SWAD, which you will have access to after the meeting, if you would like to reach out to me, or if you've got any questions, feel free to give me an email and just say I was at the presentation Saturday night and I've got questions on so-and-so and I'm happy to answer. And then also we've got the chat option. So if anybody has questions as we go along, you can certainly just type them in and we'll try and hit on all those before we end. So I am going to see if we can share screen right now. It says host disabled participant screen sharing.
Let me see if I can make you host. 1 minute.
I think she was going to make us co-hosts.
Oh, she made me host and you're co-host.
Okay.
Oh, actually, you're not even co-host. It looks like she made Shizana co-host.
Okay.
Let me.
If you can.
I'll make you host. Yeah.
Okay.
All right. Yep. You're host now.
So I have the power now, huh?
Yes.
Okay. All right. Can you guys see that?
Yes. Yes.
Okay. All right. So what we're going to be doing is I've got a PowerPoint presentation here, and we're just going to kind of walk through, going to hit the high points of how estate planning works. And normally when I'm in a room with you, obviously prior to COVID, it was really easy to see a show of hands and ask who's got certain documents and all that. So again, we'll just do the best we can with the chat option. I know there's a couple questions in the chat already, but the first thing we're going to talk about is just primarily is estate planning. And basically, it's for everyone. Sometimes when you hear the word estate, you think, oh, it's only for people who have a lot of money, but that's not true. Your estate it's your money, but it's also your family and making sure they're protected. And anybody, especially if you've got children, you want to make sure you've got some planning in place. And I think most people on the group tonight are moms or have kids. So this is definitely something you want to be thinking about. So it's basically for everybody. As long as you're 18 years old in the US, you can pull together these kind of documents. That's basically the bare minimum requirement. And you also have to have what's called legal capacity, which means you understand what you're signing. So as long as you're 18 and you understand what you're doing, you can have an estate plan. Okay, so there's some basic documents that we're going to go over. And when people hear the word estate, they always think of a will. That's just what everybody thinks. I have to have a will. But really the most important document you guys can sign is called a power of attorney. And then usually I'll go for a show of hands, but if you have a power of attorney in place, what that allows is somebody else to help you make healthcare decisions and or financial decisions if you can't do it. And the main reasons why you might not be able to make a decision would be you've gotten older and maybe you've gotten dementia, or physically you can't handle things anymore, or you've been in an accident and you can't communicate and you need somebody to step in and make those decisions for you, or you can't be located. That's the most uncommon one, but we have had people that have disappeared. And so you've got to have somebody to be able to step in and pay your bills and talk to your doctors and all that. So I think a power of attorney is even more important than a will. Even if you don't have a will, I want you to look at getting a power of attorney in place. So the other documents we will talk about tonight is a will and or a living trust. We'll talk about quickly the differences between the two of those, and then we'll talk about a living will or healthcare directive. I'm just going to check the chat and see what questions we have right now. We got some. Let's see. All right. Okay, the handouts looks like they're in there, so that'll be good. Okay. If I can move. So again, the power of attorney, it's a legal document. It allows somebody else to act on your behalf. So this is the person that potentially can pay your bills, make sure your mortgage gets paid, and all that sorts of stuff, talk to your doctors, that kind of thing. And you can either have two documents, one just for health and or then one for finances, or you can put the documents together. So it really depends upon if you want the same person to be making your financial decisions as you want making your medical decisions. Sometimes you want those split. Most of us, when we're married, we would have our spouse as our agent, but you don't necessarily have to do that. You could name a parent or a child if they're an adult, or a trusted friend. It doesn't necessarily just have to be your spouse. And sometimes people don't have spouses, so you've got to name somebody else. Right. So I have a checklist that I'm going to be making available to you all, and this is one of the questions we're going to be going over. But whenever you do your estate planning documents, you want to make sure you keep them somewhere safe, because occasionally you have to actually produce the original documents. And especially with a power of attorney, if it needs to be used to transfer real property, and when we say real property, that means houses or land, the county recorder, wherever the property is located, needs to see that original. So if you can't find it, sometimes there can be problems if the agent under that power of attorney needs to transfer land. So anytime you're doing any one of these documents, make sure you keep all your originals together and your agent or other family member knows where they are. Durability in a power of attorney just means it extends even if you become ill or sick. And generally, that's what we're going to want. So pretty much all of you, if you're going to sign a power of attorney, it needs to be durable. Make sure you see that language. And then some other things that I really like to see in these documents, it's gifting, being able to revoke a community property agreement, which we're going to hit on in a little bit, but in the state of Washington, we're a community property state. So it's a different way that we look at property ownership between husbands and wives. Basically, before you get married, everything is separate property. When you do get married, a community property pops up. And so that has to do with what people own when they pass away, or if there's a divorce, how the judge is going to distribute those assets. The community property agreement basically says between a husband and a wife that if one of them passes away, the spouse will get 100% of the community property.
Kristen, can you have the like make the part like the slides bigger?
Is it really hard to see?
No, it's not on the presentation view.
Oh, it's not viewing?
No, we can see it, but like you can make it a way that the whole slide's taking up your screen.
Okay, let me see. do you know exactly what I need to push to do that?
I think you should say a presentation, like, I can't see from here, but like PowerPoint presentation, there's like a button at the top, I think,
Okay.
or a slideshow presentation.
I'm not doing a lot of Zoom presentations with PowerPoint, so you guys just have to bear with me here. Let's see.
Is it the icon that's next to your initials where it has like an arrow? It might be that one. Where it says Kristen Reader and then the KR, and then there's like a box that has an arrow. It might be that one at the top, right-hand corner.
Let me look here.
Not that, just to the left. Oops.
Yeah, I think also like at the bottom of the page, Kristen, where it says like 65%, right next to it, there's a little what do you call
Make it bigger.
yeah.
Is that better?
No, to the left of it. You see that there's like is it easel with I think that's the presentation. Yeah.
Okay, is that better?
There we go.
Okay. So hopefully people can see that. Let's go to the next slide.
Mm-hmm.
Is that a lot better for everybody? We good?
Yes.
The healthcare power of attorney that I discussed earlier, this is so your agent or the person acting under the power of attorney can actually talk to your doctors, make your medical decisions, go and get your prescriptions, that kind of thing. So this can be really important, especially if you're in an accident or something happens where you can't speak for yourself. You've got to have somebody to be able to step in and make decisions for you. So obviously this needs to be somebody that you trust because you want to make sure they're taking care of you. For example, Swad's at the hospital right now with a birth, and we hope that, sometimes things happen with a birth. And if that mother has a power of attorney in place and there's an emergency, then the husband's able to step in and quickly make decisions with the doctor and also follow up. So that's a certain example why we'd want to have a healthcare power of attorney. And what I want you guys to know is that at the end of the presentation, there's a link where you can actually get these documents. They're online. It's called WashingtonLawHelp.org. They are kind of the basic healthcare and financial power of attorney. So if you haven't worked directly with an attorney to prepare these documents, it's good to, you could possibly go pull those documents online and get those. So when we talk about an agent, that's the person under this power of attorney that's going to be making those decisions. And when you name someone, you always want to have a backup as well, because we never necessarily know if the first person named is ever going to be able to act. So whenever you're doing this, you always want to have one person and then a backup. And hopefully these people are probably your age or a little bit younger. I have clients all the time that want to list their parents, which is fine. But once our parents get into their 70s, 80s, and 90s, they're not necessarily going to be able to speak for you anymore. So you want to have somebody your age or younger. That makes sense. Through here. Get to my next page here now. All right, so this is the will that we were talking about earlier, and this is what everybody thinks about when they are doing their estate planning. And your will actually states, I'm so-and-so, I'm married to so-and-so, I have so many kids, and these are my assets and where I want them to go. And what you're allowed to give away when you pass away is basically all of your community property. And we talked about that earlier. The community property is what you have with your spouse. If you're married, you get to give away half of that community property. And then you're also allowed to give away all of your separate property. So if you came into the marriage with property and you kept it separate, that's considered your separate property. And also, if you inherit property from your parents or another family member and you keep it separate from your spouse, that's still considered your separate property. So again, when you pass away, you're allowed to give away all of your separate property. You can pretty much do that with all of it, and then half the community property. So if there's, and then people are always questioning what's a probate, and probably everybody on here has talked or heard about that. Probate is basically a court action where if you pass away and you've got a will, somebody would be able to take that original will to the courthouse, and whoever is named in the will as the executor or personal representative, the court actually allows them with letters of testamentary then to go ahead and pay off all the debts of the person that passed away, and then put the money out where it's supposed to go. And I spoke earlier, I know we may have a large percentage of Muslims on the call, and there with Sharia law, there's actually different ways you're supposed to distribute your funds out too. So I've got a handout on that, but the US doesn't necessarily say you have to do it that way. You know, we've got a separation of church and state in this country, but I have a lot of clients that for religious reasons, they want to do things a certain way. So you are allowed to basically give your estate away to whoever you want, and you want to focus on your religious beliefs to do that as well. I touched on a living trust earlier, and a trust is basically another way to hold your property. And if anybody here ever lived in California, the probate system down there is really, really bad. It's very expensive. Regularly, it's going to cost $20,000 to $30,000 to probate an estate. You really want to stay away from that. So if any of you are from California or you're planning to move back to California, you want to have a trust. And with the trust, you actually set up a document. It's very similar to a will. And then with your assets, you're actually putting them into the trust or giving them in. The trusts are generally more expensive to set up than wills, but they're also private. So a will gets filed with the court and a trust doesn't. It actually stays private and nobody's going to see it except the people who are the beneficiaries of the trust. Again, I've hit on up there, you want to know where your original trust or will is. And I always advise people to check these documents periodically. Just because you did your will 20 years ago doesn't mean it's the way you want to have it right now. And a lot of us will start our estate planning when we have little children, and those little children grow, as you know. So once they become adults, they may be the right person to be able to act and do things for you under your will or power of attorney or whatever we have. A really important thing that you want to put in your will is who you want the guardian of your children to be. So until they are 18 years old in the state of Washington, they're considered a minor and they have to have a guardian in place if both the parents have passed away. So what you're allowed to do in your will is actually say, I want my sister or my friend or whoever to be the guardian. And you're letting the court know that's who you want. But ultimately, the court is the one that's going to be making that decision. So they are 95% sure to name the people that you want, but not necessarily. If you had named somebody and they're no longer appropriate, the court possibly could name someone else, but that very rarely happens. But it is very important to make sure your wishes are known if there was an emergency and somebody else had to take care of your kids. But I just want to let everybody know, I've been practicing for more than 20 years, and I've never, knock on wood, had both parents pass away leaving minor children. It's just really rare. If anything happens, it's usually one of the spouses might have an accident or cancer, you know, something else medical, but it's pretty rare to have both parents not be alive. And like I said, I've never had it happen in 20 years. So it's something you want to think about and make sure you're planning for, but probably one of you is going to be able to live until those children are 18. So I don't think I see any other questions here. So this is your little nutshell version of who's community property and who's separate property in the United States. So anything that's in green is actually considered a community property state. As you can see, it's mostly on the West Coast part of the country. I think we've got Wisconsin up there as community property. Other than that, everything's on the West Coast. The other states in our country are considered separate property states. So when somebody passes away or has a divorce, which hopefully that doesn't happen, the way that the property is distributed is a little bit different from the community property estates. And again, to reiterate how that works, you've got community property when you get married. That's the only time you have community property. It's when you're married to somebody. And it's all the income that's coming into the marriage is community income. All the assets that are accrued while you're married are considered community assets. And again, whatever you bring into the marriage is separate property, and any inheritances you might get from family is separate property. And so you're able to do with what you want with your separate property. But the community property generally is split between the spouses. And again, on the bottom there, I've got make sure you retain the original for your records. What we do with these community property agreements is when somebody passes away, they get, again, recorded with the county, like I said earlier, and that helps to clear title, especially if you've got a house with your spouse, then all the interest in the house would go to you. And you don't have to go through that court process. You don't have to go through a probate. It makes things very easy and simple. There's a few reasons why you wouldn't want to do one of these agreements. If you don't want everything to go to your spouse, you don't want to do one of these agreements because this basically says everything's going to go to my husband or my wife. Or if you're in a situation where you might be looking at Medicaid, and this is kind of getting out of the scope of this presentation, but there's certain reasons when you're under DSHS benefits, you wouldn't necessarily want a community property agreement. And the third reason you wouldn't necessarily want a community property agreement is that if you've got an estate tax issue, we definitely don't want to have this in place. With estate taxes in our state, you're allowed to give away $2.2 million to children or other family members without there being any estate taxes. Now, if you're married and you're a US citizen, you can give unlimited money back and forth. So that's why some people actually pursue citizenship after, like if a spouse passes and you're not a citizen, there can be beneficial reasons to become a citizen tax-wise. So I have had some clients look into that. I think there was a question about potentially immigration status or something with the group earlier. So I just wanted to touch on that. There can be some tax reasons why it makes sense to become a citizen. So a healthcare directive or living will. This is, I don't know if anybody's heard the term pull the plug, but it's kind of a tongue-in-cheek way to talk about what are the plans if you're in an accident or you're terminally ill and there's no way that you're going to become better. In the last 100 years or so, medical technology has gotten so good that they can actually keep people alive who really shouldn't be alive. They would be dead otherwise. But the medical community can keep them alive with respirators and feeding tubes and all that. But if there's no hope, what a lot of people do is have a statement saying, hey, doctor or hospital or whoever, I don't want to be kept alive if there's no hope. And then the person that actually makes the decision to stop that life support would be your agent under your power of attorney. So if you don't have a power of attorney for healthcare in place, and you're in this situation where you would probably want not to be kept alive artificially, your family's going to have to go to court and get a guardianship. And guardianships were just in the news recently with one of our people down in California. If you remember, I think it's Britney Spears, she just got out of a guardianship. Her father was her guardian. And this is a court process. It's expensive. Everybody can know your business. So you want to avoid guardianships if all possible. And again, you do that with the power of attorney. Looks like we got somebody in the chat here. Let's see what we got. Somebody said brain dead. So I want to reiterate, this is not, with COVID being in the news recently, people are kept alive on respirators, but they're kept alive because there's hope that they're going to get better and be able to be taken off the respirator. The living will and healthcare directive is in place. If there's really no hope, you're not going to be able to recuperate and come back from that illness.
Is there a difference between the DNI and DNR? Like,
Yeah, a DNR is a specialized healthcare directive that basically says, I don't want to be resuscitated with CPR, cardiopulmonary resuscitation. And that's basically somebody pushing, you've seen this probably in shows or hopefully not in real life, but somebody's actually pushing on your chest and doing compressions and trying to restart your heart. With a DNR in place, what you're saying is that I don't want anybody to restart my heart. I don't want these chest compressions, just let me die naturally. And the folks that are mostly signing those DNRs are our elder community, the ones that are in their 80s and 90s. They know they don't really want their heart restarted if they pass away. And you need to know this too, if any of you know CPR, when you're actually doing CPR, you have to press on people so hard that you're breaking cartilage. And with older people, they just really can't recover from that if you're totally pressing and pounding on their chest. So that's why a lot of folks, if you go into assisted living places or skilled nursing and you look on the wall, they actually are going to, a lot of them have those DNRs in place. And so again, the DNR is just a form of living will. The living wills that you're going to do with an attorney or the ones that are on that WashingtonLawHelp.org account that I'm going to tell you about at the end, those are more of a broad standard of what you don't want. And then the final healthcare directive that we have in this state, it's called a PULSE, and it stands for Physician's Orders for Life-Sustaining Treatment. And if any of you have been around family members that are older or going through cancer and they're really sick, a lot of times their physicians will sign one of those forms with them, and they're actually a bright green form. And that's actually something that the doctor signs. And you and your doctor decide how you're going to handle things medically. But again, you don't do that with a lawyer, you do that with your doctor. All right, let's keep going here. Okay, so let's talk about money. If you get to a point where you can't manage things for yourself, or if you pass away, somebody else is going to have to step in and take things over. They're going to have to make sure your mortgage gets paid, your utilities get paid, your investments are handled, all that sort of stuff. They can get into your bank accounts. So a really good thing for you to do is have a list of your assets. And this is good for anybody because we want to know where we are financially. Hopefully you're accruing assets and preparing for retirement and all that. But it's also so that somebody can step in and know where your things are and what they need to handle. When we're talking about life insurance, a lot of us don't get life insurance until we have children because that's when we're really worried about it. And what life insurance is going to do is provide a stream of income or a death benefit to your family if you pass away young and you've got young kids. Most of us, when we're younger and we have smaller children, you can just get what's called a term policy. And those usually last about 20 years and they pay the death benefit if you pass away when you've got those younger children. And then once we get older and the kids are older, you might not necessarily need that life insurance anymore. I'm going to talk about one way to own property. And if you see the third one down there, it says joint tenant with right of survivorship. That's really common if you have a bank account with somebody else and you're both on the account. I can pretty much bet you that the bank has set it up as joint tenant with right of survivorship. And what that means is kind of winner takes all. Whoever survives of those two people, they get the whole thing. So especially husbands and wives, when they have a joint account or you go on an account with your parent, the bank is almost always going to set it up joint tenant with right of survivorship. And that is going to trump your will or your trust or whatever you have. So this is really important for you all to understand. If you name a beneficiary on an account, or if you have a joint tenant account, they're not going to go through your will. It's going to go directly to those other people. So you want to make sure that the joint tenant agreement and the beneficiary designations really reflect what your wishes are. This becomes important if you marry, because your spouse may not be on your accounts at that point, so that, or your children, if you have a child, you want to make sure things are updated so that it accurately reflects your wishes. And here I'm talking, the last thing on this page talks about, again, estate taxes. In our state, we have state estate tax. So the only amount that you can give your children without paying estate taxes is 2.2 million. And that sounds like a lot, but when you're talking about houses in this area, especially, can get very expensive, and life insurance counts as part of this. A lot of people can hit that number. So that's something to consider. And if people have more money than that, there's some ways you can use trusts or gifting to try and reduce that amount so that the children or other family members don't have to pay estate tax. And again, with limited exceptions, you can pass an unlimited amount of money between husbands and wives. So that's good there. Do we have any questions so far about assets?
Yes, this is Shaziana. I have one question about the joint tenancy with the right of survivorship. If there is more than, let's say, 2 people on a account, and the beneficiaries and the will are different, and you said that the banks will usually divide that account based on, you know, who is on that account. So how can you protect yourself in making it so that it's reflective of the will?
Yeah. So you either don't put somebody else on your account with you, right? That's the easiest way to do it. And then it would end up flowing through your will when you pass. But that's not really realistic, because a lot of us have to help family members, or we want our husband or wife to be on that account. So there's a different hold that account. It's called tenancy in common. And what that means is that each person that is on that account owns half of it. And when one of those people passes away, their half goes according to what their estate plan says. So you have to affirmatively tell the banks this if you're setting up an account and you want to make sure your half goes through your estate or through your will. You have to tell them, I don't want joint tenancy, I want tenancy in common. And the reason why the banks want the joint tenancy, it's easier for them. All they have to do is, when somebody passes away, is look at a death certificate and then change ownership. And it's frankly making it easier for them and not necessarily for you. So if you've got a large bank account and you want to make sure that your half of that account goes through your estate plan, you want to make it what we call tenancy in common.
Okay, thank you very much.
Yeah. And if you look, if any of you own houses, if you look on your deeds, if you're married, they're usually going to name 2 people, you know, if you're married, it's husband and wife, whatever, and you've got 2 people on that deed. If it doesn't say anything after the names, actually means tenancy in common. So if the husband passes away and he's got a wife, his half is going to go according to his will. It's not like a bank account that's different. Normally they make that joint tenancy. With the deeds, generally it's tenancy in common. Although if somebody wants the surviving spouse to just automatically get that property, again, you can set up a deed to say joint tenant with right of survivorship. You can put that on the deed. But what I want you to take away tonight is that if you've got separate accounts and they've got named beneficiaries, you've got to make sure that those are current with what your plan says. And we're going to hit on this in a little bit. And I should have touched on it when we talked about our wills, but if you've got minor children, they can't actually own money until they're 18. So if you list your child as a beneficiary and they're a minor, it's going to have to go into some sort of custodial account, or the court will have to set up a guardianship. And again, you heard me talk about what guardianships are with the court. That's not something we really want to go into. So I encourage you, if you're doing your will, you want to actually say in your will that if property is going to go to my children and they're minors, that instead it stays in a trust. So you would name a trustee, somebody in your family or a friend that you really know is going to do a good job for your child, and they would manage the money for that child in trust until that child hit a certain age. And 18 is the minimum age that they can get the property, but more often than not, kids aren't ready to manage property when they're 18. So when I'm doing these trusts for clients regularly, we'll set them up till the child's like 25, 30, 35, because we're finding that's a better age for kids to manage money. So are there any questions about that?
Not about that, Christine. I have one clarifying question. Did you say that the will is defined as tenancy in common
A deed. So
or a deed?
a deed, yeah, like a deed is what you use to transfer real property, so a house or land.
Mhm.
The will doesn't have anything to do with tenancy in common or joint tenancy.
Okay.
Where you're going to see that joint tenancy most often is in your bank accounts. So if you go to your bank on Monday and you say, how is my account set up? I can pretty much tell you 99% if you're on there with a husband or wife, they're going to say it's joint tenant with right of survivorship. So sometimes that's great and you want your spouse to have, you know, all the funds or whoever you're on the account with, but sometimes you don't. So you just want to make sure you're smart and you set it up the way that you want to.
Okay, thank you.
Yeah, no worries. Okay. So this is becoming more and more important, and we all know this. We're a digital world, and we used to do everything by mail, and you'd get all your information on your accounts and your bank accounts and your bills, and everything would come in the mail. Well, that's not necessarily true anymore. More and more, we're having folks pay things electronically, do things digitally. We're on a digital program tonight. You know, this technology wasn't available 20 years ago, and technology can be a beautiful thing, but it can be really ugly if somebody gets sick or somebody passes and you can't access to any of their accounts because you don't know what the passwords are. And or you don't necessarily know, if you're getting the mail forwarded, you're not necessarily going to see bills and things that are coming in. So it's really important that if you've got passwords or ways to get into your accounts, you want to at least have one person in place that can get access to those accounts and passwords. And this can be a really big job because, as you guys know, we've got tons of different passwords for tons of different accounts, and you're supposed to be changing them all the time. So there are programs out there where you can just have one master password, that it's a huge password, and then when somebody can get into that, they can see all your passwords underneath it. So it's just something to keep in mind and realize, like, if something happened to me today, or if I had a car accident, how are people going to know how to get online? You know, even to get into, you got to think about this, you know, Facebook accounts or Twitter or whatever you've got. If they need to go in there and shut things down or change things around, you know, they need to have digital access. So what I do now in my powers of attorney and in my wills, I'm giving the agent or the executor under the will the authority to go in there and get those digital accounts. But it's a ton easier if you actually have somebody that can access your passwords. Obviously, this needs to be somebody you really, really trust, because if people have your passwords and they're up to no good, you know it can happen. So just make sure it's somebody you trust. And all the trainings I've gone to recently, they actually say it's best to keep written passwords now at home. And it sounds very old-fashioned, but they say if you're going to do at least have a master password, you probably want to have it written down and hidden somewhere in your home that's physical. It's just easier for people to find, and it's harder for a thief to pull. So it's something to think about. All right, so we're nearing the end of the presentation, and I just want to touch on a few agencies that we have in the area that can help you with all this. So The first one is Eastside Legal Assistance Project, and that's an organization that I volunteer with, and I've worked with them for a number of years. And they are out there to provide legal services, mostly for low income folks. So you have to income qualify to use their services, but they've helped with landlord tenant issues and divorce issues and all sorts of different legal issues that people have. So that's potentially an option if you need help. Sound Generations, I practice elder law. It doesn't mean I just work with old people. I work with all sorts of different ages, but they are an agency that's going to help our elders in our community. And so they've got tons of different resources on their website so if you've got parents or grandparents that live in the King County area and need help, this is a great resource for them. Washington Law Help was originally put out by Northwest Justice Project, and then it morphed into another form of agency, legal agency, but it's a really good clearinghouse for all sorts of different legal questions in Washington state. There's landlord tenant questions on there. There's estate planning questions. There's questions on Medicaid and medical care and that kind of thing. And that's what I was talking about earlier. If you just need to get a basic power of attorney in place, they're going to have example forms for you on Washington Law Help. So that's definitely something to check out. And then the Washington State Healthcare Authority, they're the ones that actually manage healthcare. If you're on the exchanges or you need healthcare and you're not part of a plan through your employer, that's where you're going to want to touch base to try and get medical care set up. Let's see if there's anything else I haven't touched on. Can you see, is my long-term care checklist on the chat? I can't tell if it is or not. I'm going to encourage you all to talk to SWAT after this and get the questionnaire that I sent out to everybody. And then also the handout on the Sharia law. It's really interesting to see kind of how that differs from the regular way that money would flow. So I think it's something important for people to check out there to make sure you're following, your religious edicts and making sure that's appropriate. Do we have any other questions? We're at about an hour here now, so I don't want to put you guys to sleep.
No, I actually have a follow-up question. So for an example, for an asset like a house, I think you mentioned like for deeds, I'm assuming that this is joint tenancy with the right of survivorship. If there is a current will in place that does not follow that joint tenancy with the right of survivorship, how can we reinforce the will?
So by default, if you buy a house with somebody, it's generally not going to be joint tenant with right of survivorship. It's going to be tenants in common. So that means that each half is going to go according to that person's will. Unlike bank accounts, they pretty much always set it up joint tenant with right of survivorship, but deeds not so much unless you specify it. If you tell them I want joint tenancy, then the person who's preparing the deed will do that, and then it just goes to the survivor. But for most of us, especially with our houses, we want it to go through our estate plans.
Okay.
We have something in our state called a transfer on death deed. It's been around for about 7 years. And this is another sneaky little way to avoid a probate. So for example, my clients that are older, their spouse may have passed away. They've got a couple adult kids. They want to make things really easy when they pass. They can redo their deed so that it says, hey, upon my death, my house is going to go to these 3 kids. And it's kind of like sticking a will into your deed. And that way you can avoid a probate of that actual will. But again, yeah, that's going to trump the will. So anytime you've got named beneficiaries, that's going to not necessarily follow that will, especially if you've got retirement accounts. You've usually got to name a beneficiary on those. Just it follows like what your will says.
So can anyone complete the transfer of death form, does it have to be when the mortgage is being paid or when the mortgage is complete, or it doesn't matter?
It doesn't matter. So the way mortgages work, most of us have them, right? Because most of us afford a house with cash. Some people can, and that's great, but I have a mortgage, most people do. The way mortgages work, the bank owns part of your house basically until you've paid them off. And when you sign paperwork to buy a home, you have to sign a promissory note. And that is secured with what we call a deed of trust. And security just means that they're putting the public on record that they are owed a certain amount of money. So it's you can actually look online in the King County Recorder's Office if you own a home, and you'll be able to see your deeds. You'll be able to see if there's a deed of trust against your house, and the mortgage company is not going to actually remove that deed of trust until you've paid your whole mortgage. And then when they do, it's called a satisfaction of deed of trust, and then that gets recorded. But as far as you passing away and giving your house or part of it to people, it doesn't matter if there's a mortgage on it. There's actually federal law that says if you've got a surviving spouse or children and you give them a house that has a mortgage, the mortgage holder has to continue to honor that mortgage for those children. Not necessarily if you gave the house to like a friend and there was a mortgage on it, the mortgage lender could call the mortgage immediately due. So they'd either have to pay it off or sell the house. But for immediate family members, they're able to continue with the mortgage.
Okay, thank you.
That's called it's the San German Act. It's been around 10 to 15 years, but because it's a concern, you inherit a house from your mom or dad and you can't pay off the mortgage, and they're like, well, too bad, you got to pay it off or sell it. So it allows family to continue to pay these mortgages.
Okay, thank you.
Yeah. Let's see if there's anything else that we didn't touch on.
Yes,
What
we
about
have
if you don't?
we need Somali interpret. Hello?
Yeah.
Habay.
I
can help out.
Waxaan u baahanahay turjubaan u baahana baa waxyaalaha qaar waa fahmaya waxyaalaha qaarna ma fahmayo.
Okay. maxaa hadda aadan fahmin walaashay waxay ka hadlaysaa micnaha waxay ka hadlaysaa iyada hadda maxaa la dhahaa ii sheeg aday wiilkay ka hadlaysaa hadda macnaha su-aal maa qabtay oo rabtaa in lagu sharxo she speaks Somali, so she doesn't understand most of the stuff. I'm trying to help her out to explain.
Su'aal ma qabi ilaa se maraha qaar in loo turjubaan waa iskaga baahnaan leh.
Okay. Hadda iyada waxay ka hadlaysaa dhaxalka iyo waxyaabahaas markino qofkii oo kale caruurtaada ugu tagi kartaa isteedka sharciyo badanaa jiro oo ku shaqo leh waxyaabahaas dhinacii oo muslimkana gaar waaye tiri xataa dhinacaas waxay dhahday waxaa hayaa waraaqo aan usoo gudbin karaaye dhahday qofkii micnaha oo u baahan laakiin isteedka dhinaciisa badanaa ka hadlaysaa laba qof hadday guri isla haddii hanti aad leedahay qofkii aadayso micnaha ay qofkaa ku qoraysid iyo caruurtaada haddaa ugu tegaysid iyo odaygaaga ama qofka magaciisa waa inaad sheegtaa aa ugu tegaysid hantidaada.
Okay, waa mahadsanta baa.
walaasha
سعاد
أسيوة ولا سعاد ما سعاد ما
اوكي فاطمه واye maxaa hadii account oo bangi aa qabtid oo safe box aa qabtid lacala hadii oo markaas oo aan dhinta matalan hadii aan dhinto marka ilmahayga ma siinay mas warqad inaan qor waa marka iigu u sheego qofka siinano
safe box waa mo safe ka oo account bangiga. Okay. So her question is, if she has a safe deposit box at the bank, if she passes away, are they going to give it to her kids directly, or does she have to write a will or letter indicating that it should go to my kids if I pass away or something happens to her?
So the first thing, safe deposit boxes if anybody doesn't know what those are, it's a box that you generally keep at a bank. And a lot of times we're putting our home deeds in there, we're putting our jewelry in there, things that we really want to protect, gold coins, that kind of thing. The only people that can get into that box are you and anybody else who's on that account. And so they just have to have a key and they have to be on the account. So if you've got a safe deposit box, and I have a lot of clients that do, and they keep their documents in there, you got to make sure there's somebody else on the box. And it probably shouldn't be your spouse to start, because if you guys are in an accident together, nobody can get in. And I have to do as the lawyer is go to court with a petition and an order to get the judge to give me an order to be able to have somebody get into that box. So that's step one. Make sure you've got somebody else on the account that's probably maybe outside of the family, somebody you trust. And the things that are in that safe deposit box. So we're talking, this is called tangible personal property. So for example, you've got your diamond rings in that box. If you specifically want somebody to have those diamond rings and you don't want there to be a big fight in your family, you do want to have something in your will that either talks about those diamond rings, or what you can do in this state is when you've got a will, you can say, hey, I have a separate list that's close to this will, and I've written things that I want specific people to have. And that's called a tangible personal property list. And that's where you'd actually list that ring and say who it's supposed to go to. You can specify certain people have certain items like that through your will, but then to be able to get access to them, just make sure you've got enough people on that safe deposit box that it's going to be easy to get into it if there's a problem.
معناها قف كلا waa inaad ku darsataa oo bangiga markaa furinayso waxaa leedahay dadaa magacooda u sheegaysa waxaa leedahay qofkaas iyo qofkaas hadduu imaado waa geli karaa safe deposit boxkayga account-kaaga macnaha inay kugula jiraan furahana aad siisid macnaha waxay dhahday odagaaga ha ku qorin sababtoo waxaa dhici karto adiga odagaaga inaad shil isla gashin oo hal mar isla dhimatiin marka qof aaminaysid waxay dhahday oo isku hubtid aad ku qoraysaa si qofkaas inta uu tago oo markii hadhowtu wax ay dhacaan uu soo bixiyo box deposit box wixii ku jiray haddii aad meesha gashi sidoo kale dahabkaaga ama wax macnaa ma arkino farantigaaga oo luulka iyo waxaas oo muhiim ah waxaa dhehaysaa wixii ka soo baxo meeshaas gabadheeda iskale magaca qoraysaa gabadhaasa iskale wiilkaasa iskale magacooda meesha ku qoray markii wixii laga soo bixiyo boxka
because hadda waxa soo fiicaya moogtaa in la ogaado
muhiim waay sax
okay thank you.
The thing with those lists too, that's really nice is that when you have to change your will, unless you're using like an online program, you're using a lawyer and they're expensive. So you can do your will to give away your money and that kind of thing. But if you've got specific items of jewelry or other family items, and you've got that separate list, you can always take that list and tear it up and do a new list and redate it and re-sign it. And you don't have to keep going back to the lawyer for the will. So again, the only things you can put on that list are that tangible personal property. So we're talking about our jewelry, antiques, anything that's sentimental value that you can actually hold in your hand. Those things can go on that list and you can change it anytime you want. Otherwise, if you're doing a will, it has to be witnessed by people. There's certain requirements. And those powers of attorney that we talked about earlier and the forms that you'll see online, most of the time, those have to be actually notarized. So if you all have maybe seen a notary stamp before, it's usually a round or square stamp and you have to sign that paperwork in front of a notary. So there's certain requirements when you're doing all these documents.
So the power of attorney and the living will are two separate documents, or?
Yeah, so everybody gets confused about that. The living will is just a statement of what. So the living will, again, is just saying, hey, this is what I want if I get really sick. And then the person that makes the decision is that healthcare agent under the healthcare power of attorney. They're the ones that will look at the living will and then make the decision.
So
and what if you don't have it? Sorry.
So if you don't have a living will and you've got a healthcare agent, they're in kind of a world of hurt, really know what you would want. So that's why we want to do those advanced directives. I mean, the worst thing you can do is be in the hospital and have to decide if you want to take somebody off life support and you don't know what they want. So it's good to have those forms. But a lot of us don't. I mean, that's a question that was just asked. Half the country doesn't even have any planning at all. So, I mean, I can't see a show of hands right now with you all, but a lot of people just don't have these documents. So if you don't have the documents, the state law will actually step in and make those decisions for you. And it might not be the way you want. So if you want the most control, you want to do your own documents ahead of time. It's just something you have to make time for and just do. And then usually you can forget about it for a while, but it's really important to get this done.
So can you have the same person for the POA and also as the executor of the will?
Yeah, a lot of people do that because it's usually the person that you trust. So certainly that's no problem. And then the power of attorney is only when you're alive. And then the will is when you're dead. So you can definitely have the same person do the power of attorney and then also do your will. That's not a problem.
So can you trying to differentiate between the healthcare directive and the POA for the health side? What is the difference between those two?
The POA for health is the most important document because that's actually naming somebody to make legal decisions. You're actually giving somebody that authority. Your healthcare directive, your living will, your DNR, your posts, that's all just something you're saying, hey, this is what I want to happen to me. It's basically you're writing a letter to somebody and saying, this is what I want. But then the person that has to interpret that and make the decision, that's your healthcare agent under the power of attorney. So if you have to have any documents at all, you want to have that power of attorney. That's the most important.
Okay, perfect. Thank you so much. I appreciate that.
Any other questions?
wax su'aal kale ma qabtiin walaal
I
Hello?
just have one more question. So how is like the chain of the legal next of kin? Like, how does that work? If you don't have a power of attorney or a living will?
Yeah, and half of us don't. So again, what she's talking about is next of kin or the laws of intestacy. The government has to step in. The government has to step in and decide who they think you would want. So in an emergency situation, you don't have a healthcare power of attorney, it's going to start with your spouse, and then it's going to be your adult kids, and then it's going to be your parents, and then it's going to be your siblings, and then it's going to be your nieces and nephews, and then it's going to be your cousins. Those are all the people that can give informed consent in an emergency situation. And those are also the people that would inherit your property if you didn't have a will. So some cases you wouldn't want your spouse to have all of it, or you wouldn't want your kids to have all of it. So that's why you do a will. But if you don't have one, that's the way it's going to flow. It's going to go through that bloodline. So the state will come in and they will make a decision, but it might not be the way you want it. So that's why you want to have the documents in place.
So
let me
I
just
have a
explain in
question.
Somali for a second. Marka waxay leedahay walaal haddii waxaa fiican inaa sii diyaarsatid adi micnaha dhaxalkaaga inaa qortid wixii sida loo kala dhaxlaayo sidii waxaaga aad u kala qaybinaysa hantidaada iyo wax walba intaa nooshahay sida diinteenaba ay dhigto micnaha haddii kale waxay dhahday statekaa waxba kuu qaybinaayo ma fahmino ha laakiin intaad nooshahayba arrimahaaga meel iska saar wax walba ha go ahead please.
So I have a question. So like, as you're saying about property, if somebody doesn't have power of attorney and doesn't have will, but sometimes it's happened like in our, like as a Muslim, we follow our religion. So in our book, like if someone die, they have already, there's something like a share for the property or everything, like who will get the how much part and who will get. So can we if government involved, can we show them this one too, like is our religion, and according to our religion we want to divide this property in case it's not going to be happen, but in case. So can we show them proof that this is a the property that we follow according to our religion? Do they appreciate or respect this thing, or they want to do their own self?
So I don't know for sure, but my gut instinct would be they're going to say, you know, you've got your religious beliefs, but if this person did not put it into writing, we have to follow what the state law says. That's going to be the primary law. So if, and I'm looking, I gave you a handout, which you guys can see later, but it looks like Sharia law allows you to split things into thirds. Like you can give a third to whoever you want, and a third goes to the family through a bloodline. If it's really important to you to follow that law, then you've got to put that in writing, because then that will trump whatever the state says.
Oh, good.
Nothing
So
in
maybe-
writing, the state's going to
Okay.
follow the state law.
Okay, but if someone who have wills, like I want to do this, like according to my whatever my in our religion, the daughter can get the one part and the boy get the two part. So it is somebody if want to, they can already make any wills or something like I want to follow according to my law of my
I have
religion.
people do that. Yeah. You put in your will, I'm a practicing Muslim. I want to follow Sharia law. This is how I want my property to go. And then you'd list it out. And then it's very clear to your executor under your will how you want things to be handled.
Oh,
As long as you put it in writing, it's going to be followed. If you don't, you know, and good luck fighting with the state of Washington. It's going to be harder. So you want it in writing.
Okay. Thank you so much.
Yeah, yeah. Anything else? And like I said, if you've got a follow-up question, you can always just shoot me an email and we can talk about it.
Kristen, thank you so much. I have a question about how much we should budget if we do not have a will, if we don't have a power of attorney, or even the medical directives. If we're starting from scratch, how much financially should we consider? And also if you have a time estimate of how long it takes to get all this done.
Well, as far as the time estimate goes, like for me personally, when I see somebody to when we're ready to sign the documents, it's about 3 weeks because I have to have time to get everything drafted. But I have done wills in a matter of hours. If I know somebody's dying and it's a matter of hours, we can get it done pretty quick. I mean, obviously I have to shove everything else to the side, but I will do that in certain circumstances because we want to get all their plans in place before they pass. And then a rough idea of cost, like if you're working with a lawyer, it really kind of depends on the area. The immediate Puget Sound core is going to be more expensive than farther south or on the east side of the state. So the farther you get away from the metropolitan area, things are going to get cheaper, and that's kind of in general. The rule of thumb I've kind of heard is you're usually looking for a single person to do a plan. It's usually $800 to $1,000 for like all the documents if a lawyer's helping you. And for a couple, usually you're doubling that. And then for those folks that have those bigger estates, like over that 2.2 million, there's certain types of trusts that we're drafting into their plans, and then it gets a little bit more expensive. And if we're setting up trusts for the kids, that'll get more expensive. So if you're working with an attorney or you're thinking about hiring one, you always want to ask ahead of time, you know, what do you think the fee estimate is? And the attorneys aren't going to do the work until you agree on a fee and you make sure you're comfortable with it. And then there's forms you can get online too to do this work. And you've probably heard there's LegalZoom and there's, I think NOLO is one of them. You can pay like $50 to get a plan in place, but there's things that you work with a lawyer that are, you're going to get probably better counsel than just doing the forms, but everybody's different. And like I said, everybody who's on the call tonight, if you're over 18 years old and you don't have a power of attorney, I would suggest going to that Washington Law Help site and getting a power of attorney and getting it signed, at least to get started.
Mm-hmm. Thank you so much.
Yeah. Okay, guys, well, it's 6:15. I think we're going to call it a night. And thank you for dealing with our technical issues and helping me figure out how to do my PowerPoint there. So I'll know for next time.
Yeah, 401k guy in mortgage guy, yes.
And then if you've got any follow-up questions, just feel free to give me an email. That's not a problem.
Thank you so much.
Guys, say goodbye.
Thank you.
All right, bye, guys.